Hello everyone, I am Priyanka Mondal. I am a PhD student at William and Mary. In this video, I am going to talk about our work on investigating the US legal perspectives on liability for IoT product security. This work was done in collaboration between security and law researchers from William and Mary. As we all know, there are billions of potential vulnerable IoT devices available in the market, and considering that fact, public sector is focusing on the security and privacy of the IoT products. For example, FCC announced the US Cyber Trust Mark for smart devices, which is currently being implemented. These policy initiatives are encouraging vendors to maintain higher security standards for their IoT products, and hence they are opting for IoT product security certification. For that, vendor pay to the certification lab who do the assessment and provide certification. However, in our prior work, we found that the certified product can have known and common vulnerabilities, which may give false sense of security to the consumers as they tend to believe in the certification. As a result, consumer may suffer harm resulting from exploitation of the vulnerabilities in the IoT products. In this case, who is legally responsible? The labs or vendors or anyone else? That is, the liability is not clear. So we ask this question: who is liable for harm resulting from vulnerabilities in the certified IoT products, and who should be so liable? This question is important because establishing liability in the event of security and certification failures is critical for accountability in the IoT security certification infrastructure. Therefore, we want to investigate this question guided by two key research questions. First, we want to assess how do IoT vendors describe liability in their contracts with user. And next, what are legal experts' perspectives on liability? To answer research question 1, we performed user agreement analysis. And if we want to investigate the current state of liability, we need to understand how vendor draft the contractual documents, which are called terms of services or end user license agreement. Therefore, we collect 20 documents from 20 IoT vendors. And through a collaborative process between security and law researchers, we qualitatively analyze those documents by creating a codebook based on legal theory and the current liability landscape. Next, we performed a legal expert survey to answer research question 2. Here we want to know the legal practitioner perspective on liability because legal practitioners involved in drafting contracts and defend vendors or bring legal proceedings on the behalf of users. Specifically, we want to explore their perspectives on who is responsible and who is liable for IoT product security. We conducted a survey with 18 lawyers with diverse field of expertise. Overall, we have 14 exciting findings. Now, I am going to talk about some of the findings very briefly. Now, let's see some of the interesting findings from our user agreement analysis. We found that vendor uses striking clauses to essentially shielding themselves from all liability. For instance, while excluding liability, they exclude something, here the personal injury or death, that are not even permitted under US law. Now look at this example. It says their product are not intended to use for safety and security purposes, and they are not responsible for any damages caused by those devices. Interestingly, these vendors have products like security camera and door lock. Then what does that mean? And a common thing we found is that there can be ambiguity in the clauses, like this example. Here, what kind of batteries are inferior quality? That is totally vague to users. And these are the three different examples shows three different cases. And we found more issues like this in our analysis. Now let's see what we found in our legal expert survey. We found that our participants hold IoT vendors liable by default as they designed and implement the security of the product. On the other hand, participants think that the liability of the certification lab depends on the contracts with their vendors and the nature of the vulnerability. That is, the lab can be liable if the vulnerability are within the scope of the standards they follow, but it also depends on what kind of contracts established between vendors and labs. And when we ask participants about their opinion on the impact of the US trust mark, which I mentioned earlier, participants identified three key factors that determine the success of this kind of program. First, the quality of the certification process, and next, the adoption rate by the vendor, and finally, the consumer's knowledge about the certification. Further, they outline both positive and negative impacts. They think that this trust mark can improve the overall product security. However, they also think that the following certain guidelines may lead to significant number of vulnerabilities unaddressed. Therefore, from this study, we have seen that the contract have several flaws and need significant improvement. Further, there is a gap exists between how contract express liability, that is, if we see that the vendor are most likely disclaim all liability, while legal experts think that the vendor are the primary liable entity. Not only this gap, it is still not clear how liability is defined for the compliance certification ecosystem. However, these legal considerations are central to the future of the vulnerability research, and for vulnerability research to be fruitful, the legal consequences of vulnerabilities must be clearly understood. Therefore, we can say that there is a need to introduce a clear liability framework that will create an incentive for IoT vendors to ensure that their IoT product meet proper security and privacy standards. Thank you for listening my talk. Please feel free to read our paper for more details and send me an email if you have any question. Thank you.